we leave a digital footprint behind every time we use the internet, every time we send out text messages, every time we use our phones to take photographs. We see that in the practice of law too when we're dealing with cases. Everybody wants the metadata, to basically determine when a document was created.
Hello and welcome to the next episode of Beneath the Law. My name is Gavin Ty. I'm here with Stephen Teal, my friend.
How are you doing, Gavin?
I am pretty good, Stephen. Pretty good. Interesting topic today. We got a few of the recent stories in the media and really raises the issue. And as we live in a world that is increasingly driven by technology, believe it or not, increasingly. Every time I think of that, it's hard to believe it could get more driven by technology, but it seems to. And everything we do or say or think or look at, frankly, is tracked. There is a record of it somewhere, somehow. There is some sort of evidence as to what we have done, where we have been, who we have spoken to, what websites we visited, you name it. Do you find that a little Orwellian and troubling? Wow, do we ever live in a world where Big Brother is certainly watching and has the capability, frankly, of watching you far more, I think, than George Orwell even imagined? I had a case recently involving, and I won't use any names or what have you, but just a concept that was quite interesting. For an employer that had employees who were in the field, and it was part of their job to be in the field, and they traveled around and did various things. Doesn't really matter what industry they were in. And the employer had installed a program on their telephones that allowed the employer to track where they were and how long they were there. It was referred to as breadcrumbing. I guess the old Hansel and Gretel analogy. Well, breadcrumbing was a big deal, and the union grieved that, and etc. But what's on our phone, Stephen? Whose property is it?
A really good question, Gavin. Look, we leave a digital footprint behind every time we use the internet, every time we send out text messages, every time we use our phones to take photographs. We see that in the practice of law too when we're dealing with cases. Everybody wants the metadata, to basically determine when a document was created. So we're leaving all these digital footprints behind. Whose property does the phone belong to? Well, some interesting cases, as we know. Court of Appeal came out with a decision last year dealing with a couple of teachers, I think it was York Region, who were basically emailing back and forth with respect to, I guess, a dispute, and a school principal saw the open computer, took some screenshots of it. It was the computer that was provided by the school board. The school board made the argument that it was their property that was being used by the teachers. The teachers were actually disciplined because of what they wrote back and forth, and the Court of Appeal essentially found that the teachers had a reasonable expectation of privacy with respect to the messages that they were sending back and forth, because they were using, I think, Google accounts, which were on the cloud and were not stored on the computer. So, one of the biggest factors as to who does the phone belong to, was it provided to you by your employer, or is it your personal phone? So pretty interesting issues with respect to that. When somebody uses a private phone, there's lots of expectations of privacy from the people who call you on that phone or text you on that phone. You may be dealing with medical issues. You may be dealing with a lawyer. So even if it's a employer's phone, a lot of that stuff is private. And if the employer has an expectation or understands that it's going to be used for private purposes, there is that reasonable expectation of privacy that you have in that phone or in that computer. Yes, there can be monitoring of your internet use or your email use, but there is a line that basically would suggest that that still remains private.
So let's talk about some pretty notable, if I can say that, examples that have come out recently of snooping into other people's phones. One incident that occurred that I think inspired us to want to talk about this initially was, very well-known hockey coach Mike Babcock, who was no stranger to controversy, and kind of an old school guy, if I can say that, in terms of hockey coaches. I'm not saying that whether it's a good thing or bad thing, but he's certainly from a different era. And Mike Babcock took over coaching of a new NHL team, and one of the first things he did, in fact, he never got out of the gate. I don't think he made it to the pitch the season, because he snookered himself because he pulled a move where he would get younger players. Well, they're all younger, and he said, "I want to see your phone. Give me your phone." And he'd go through the players' pictures and I don't know what else, whatever he wanted to. And that raised the ire, I take it, of a number of the players. And ultimately, I understand, led to his being dismissed as the coach of the organization. There had been too much, I guess, friction between him and the players to start with over this phone issue. What about something like that? He's the boss. He's the coach. Is he entitled? Is the boss entitled to go through your pictures on your phone?
No, I don't think the boss is entitled to go through your pictures on the phone. Look, I think Mike Babcock's situation, Gavin, is a little unfortunate from a number of levels. He had asked the players. It wasn't like he confiscated their phones to show them pictures. I guess he wanted to get to know them better. Employers or bosses and underlings, frequently go out, they get together, they have chat. You do want to kind of know what the background is of your employee, or, what they do, in their spare time. There's camaraderie built through that. But in Mike Babcock,
come on, come on. Get to know you better. I want to get to know you better. So let me go through your underwear drawer and see what's going on. I mean, that's a bit
well,
much.
No, I think you don't understand the context that I'm speaking in.
You're right. Maybe I should go through your phone and then I'd understand.
Yeah, and then
I get to know you better.
Then I bring you up to the executive committee. But you're on the executive committee, so I don't know where that leaves me. Look, was it appropriate thing to do? Probably not. But he went beyond just going through their phone. My understanding is that he actually displayed it up on TV screens for others to see what was on the phone. Now, some of the players, my understanding, didn't have a real problem with it. They just thought it was chit-chat. But obviously somebody must have complained about it because the story broke through third parties. So somebody must have felt uncomfortable. I would certainly feel uncomfortable. Most employees would feel uncomfortable. What the heck is the boss wanting to do going through my private phone? Like, that's nonsense. And
it's a power play.
There's a hockey analogy. Look, first of all, those phones aren't issued by the team to the players. These guys can certainly afford their own phones and their own accounts. And that's private stuff. The employer shouldn't be in the private business, as you say, the drawers of their employees. And, for Mike Babcock, you're right. Look, he's an old school coach. He's done various things in the past. We're from Toronto. Mike coached the Toronto Maple Leafs, and in Mitch Marner's rookie season, my recollection is that he asked Mitch to provide a list of the players, ranking them in order in terms of their work ethic, and then actually shared that with the team. So
it's a breakdown. Yeah, I agree with you on all of those fronts. I mean, I think it's the old school coaching approach that I gotta break you down before I build you up, and that breaking people down to show that you have all the power over them and they have no power over you. I mean, it might be designed to achieve a purpose of bringing the team together, but it is just so inappropriate. And in the hockey sense, it's one thing for an employer who provides an employee with a cell phone and then the employee as a tool, frankly, of their business, and then is monitoring what the employee potentially is doing on the tool of the trade, so to speak. But there's nothing to do with playing hockey that's on your cell phone that I can think of. Off the top of my head, I suppose it's all part of the teamwork.
Well, look, it probably has a bit of a nefarious purpose, right? It's what do you do as the employer? Oh, I saw some phone that I'm going to keep in my back pocket to use against you at some point in time. Like certainly that would make me feel uncomfortable if somebody came into my office and said, "Stephen, I want to see your iPhone." Now, quite frankly, I don't use a employer iPhone because look, my phone is personal to me.
Of course, and it has become the virtual. Everyone's life is tracked on their devices these days. Everything about a person is probably knowable from their device, where they've been, who they've spoken to. Everything is there. It's all available theoretically for a forensic audit by whomever. So in terms of employees and employers, the Babcock incident is one where the employer, if you will, the boss got in trouble for going over the line in terms of intrusion. But it raises interesting issues from a legal perspective is what are the rights of people with respect to privacy? And I think that just for a way of background, I mean, again, hopefully there are lots of people listening to this podcast who aren't lawyers, but in Ontario and around the world, the notion of privacy, of boundaries, of stepping over those boundaries, of being something that you can litigate about is reasonably new. It has reasonable developments in the law sort of on the periphery. And there was a case in Ontario a number of years ago that sort of highlighted it from my perspective, which was a case that came out of the Court of Appeal of Ontario, a pretty sad saga, a case called Jones and Siege, and I'm going to mispronounce that last name. But the case was an interesting story, and it was sort of a love triangle gone wrong, where individuals were employees of the bank. One was dating the ex-husband of the other. The ex-wife was very curious about the financial dealings of the new girlfriend, and as an employee of the bank was snooping around in her accounts. And I can't recall the number, but had been viewing her account probably more than the person whose account it was, and was looking at it on a daily basis to see, where they were buying their coffee and donuts. And they were sued for that, for what was referred to by the Court of Appeal as intrusion upon seclusion, which is in the sense that you've got somewhere that is your safe space, it is private, and someone who intrudes on it, if they trespass, for lack of a better word, into your privacy, that is actionable. Now, it was pretty egregious, the conduct of snooping around, but the damages were fairly nominal. So in Ontario, there are 4 related torts that relate to this type of conduct, but they're all pretty much the same thing. And those are intrusion upon seclusion, which is the case that came out of the Jones case I mentioned, public disclosure of private facts, which is another tort which is similar, then publicly placing a person in a false light, which is to try to defame somebody, frankly, in some way, shape, or form by the use of their personality. And then I guess the commercial flip side of that coin is the appropriation for the defendant's advantage of the plaintiff's name or likeness. And you can see the last one in a commercial context would make a lot of sense for, a celebrity or a sports figure who makes a lot of money endorsing products, if their image or what have you can just be used willy-nilly by anybody, then their image isn't worth very much. And frankly, that's an interesting concept, that one's personality or likeness is actually a commodity that can be bought and sold. And when we think about it, for example, in the endorsement context, it's pretty easy to see how that works.
Well, there used to be a well-known case, and I actually forget the name, notwithstanding that it's a well-known case, of a Hamilton Tiger Cat football player whose image was misappropriated, I think, by a car dealership in the maybe late 1960s, I guess that case dates back to. And it's a tort, right? Misappropriation of the personality. So, look, Jones and Siege certainly advanced the law with respect to invasion of privacy interests. And I think a lot of those torts actually come from the United States and are beginning to filter into Canadian law. I'm not sure that Jones and Siege is national across Canada in terms of every province looking at invasion of privacy from the common law perspective. Certainly we have privacy laws here in Canada, across Canada, which are really important. And, getting back to remedies in the employment context, and I think we would be remiss to not mention this, but where an employer breaches the privacy of their employee, an employee may have a right to claim that that's a constructive dismissal, because it's really a breach of the duty of good faith and fair dealing between the employer and the employee. And when your employer gets into your private stuff, that's a breakdown of the trust relationship between the employer and the employee. So potentially there's a cause of action there. And I can recall that there's a case where an employer set up a secret video camera in the office of a very trusted employee.
Guess they weren't so trusted.
Well, right. Well, the employer, who knows what I haven't read the case in quite some time, or the facts of that decision, why the employer did it, but that certainly led to the employee, I believe, suing for constructive dismissal.
Well,
and winning.
In addition to constructive dismissal, I mean, there are these torts that we mentioned. The employee could theoretically sue for any of those causes of action, or some of them, and could also make, I suppose, a complaint to the Privacy Commission.
Correct, right.
So there are remedies in terms of this trespassing, if you will, on one's private space. Now, that's where the intrusion upon your seclusion, in the sense that I love it. That does sound pretty good, doesn't it? It does. It's probably the most lyrical tort I know. It's like, but anyways, the intrusion on your seclusion is actionable one way or the other. But you raise an interesting point, and it reminded me of a case that I'm involved in at the moment. And I'm no names involved, and I'm not here to talk about cases. This is actually an active case, but there's a case, we see it all the time, where, for example, in real estate marketing, is often now online. You can go online and see all sorts of listings of property, and there's obviously photographs of the property. But in the slicker, if I call it that, marketing packages, you'll often see video footage of a walkthrough, a 360 type virtual tour of the premises, and sometimes.
Right, not just the inside of the premises, but from the outside.
And then you'll see an aerial drone footage. I mean, you see drone footage all the time of particularly, beautiful properties, like rural, like lakefront properties. You have a drone footage of it looking at it. And condos often will have drone footage. And I have a case right now where there is a claim about drone footage used in the marketing of a condo property, where one of the neighbors alleges that there was inappropriate intrusion on their seclusion, and catching them in an act that they said was not for public consumption. And that drone footage, they say, hard to see it on the drone footage, but they say, being published on the net to market the property, neighboring property or neighboring unit, was an invasion of their privacy. That's a real, you can see that might be an issue.
Look, for sure, look, Gavin, drones are becoming more popular. We've got, people are obviously paying attention, I think, to what's going on between Russia and Ukraine and how drones are being used in the war setting. But look, a drone has various industrial and recreational uses. Drones are now being used to deliver goods, or certainly that concept and model is being thought about much more. Drones are being used in policing, and that raises a significant privacy issue. It raises a significant charter issue. Is it an unreasonable search if police are flying a drone over your property to look at what's going on without a warrant? So these issues are becoming more and more real. Obviously, in the private context, I know condominiums that have actually banned drone flying on their properties. I believe that there are certain real estate boards that actually prohibit now real estate agents from using drone footage to market properties because of these privacy concerns. A drone is not just a toy. It's, taking photographs, building memories. These drones have incredible capabilities. They have follow me capabilities, FPV capabilities.
What's that?
They're fantastic tools.
What's FPV? Sorry, pardon my ignorance.
So essentially, a drone can be set in two ways. One, it will follow you, so you set a specific target. It will then basically focus. So if I'm, let's say, riding a bike on a trail, it will actually follow behind me. But I can also set it up that it will always film me from the front. So if I walk, it will actually move away from me so that I'm still face to face with that the drone is still facing me from the front side. So it's like these things are just incredible tools with their GPS positioning and locations. But there are restrictions in terms of flying drones as well. So I think that's the real issue with respect to drones, and IPC commissioners, information and privacy commissioners, have commented that there's a huge gap in terms of the regulation of drone flying. And my understanding from reading reports is that Transport Canada, at one point in time, basically had a regulation or a proposed regulation that would have prohibited a drone from flying within 75 meters of a building. And then that was dropped. 75 meters is a pretty long distance. But you're seeing drones, certainly for real estate purposes, flying right up to the, side of the windows of these properties. So,
yeah, I mean, but that's, to me, that's, there's a couple of issues that are there. I mean, I know, for example, first of all, that drone flying is a safety risk. So, for example, I know you can't fly your drone near an airport, which makes pretty good sense.
Correct.
You don't want these things flying around and causing accidents or crashes anywhere near an airport. And they are, anyone can operate them. You can buy them pretty much anywhere. I don't know. You don't need a license, as far as I know.
Depending on the weight, right? So if it's a drone that is weighs less than 250 grams, you don't need any kind of certification or registration. If it weighs more than that, then you do. You need to take, some courses, that are complementary to being like a commercial pilot kind of course. So the weight of the drone is important. But look, most drones for recreational use, these companies build them, DJI, for the strict purpose that you don't need to go through a very strict process. Now, I own a drone, Gavin. I went and I flew it in the United States, so I had to get what is called a trust certificate through the FAA. So I had to take basically a 30-minute certification program that I understood the rules, that I can't fly it more than 400 feet. That you're not supposed to fly the drone if you can't see where the drone is, right? You have to have you have to have eye contact with your drone. So there's all kinds of rules, and if police came, I have to carry this certificate with me to show that I've actually gone through this process. So, there are some rules around drone flying, but there are a lot of issues right now that are still in a very gray area with respect to privacy issues and drone flying. And, I mentioned the police. There was a case a couple of years ago in Michigan that basically upheld or threw out, evidence that a town was trying to use against a property owner because they didn't have a warrant when they flew the drone over the property to find out if they were using their property within the zoning parameters of the town. So,
so there's a couple of interesting issues here. First of all, let me state that while anyone who listens to this podcast may know that I do often drone on, I don't own a drone. So I don't, and I know precious little about them. But there are a number of more insidious uses that that you mentioned. First of all, number one, you mentioned that, drones have been weaponized, definitely, like directly weaponized. We were hearing about drone attacks, delivering of explosives in the war in Ukraine, number one. But I think more importantly is what you've just mentioned is sort of this surveillance aspect of the drone, which is pretty insidious to my mind, because they are so intrusive, and they have the ability to look into areas, frankly, that are not easily accessible. So for your municipality issue, they have the ability, obviously, with a drone to look over the fence, whereas the municipality may or may not be able to. It raises pretty interesting issues as to whether or not, just like, are the police allowed to search your home? If the answer is no, but are they allowed to fly a drone up to the window of your house and have a peer through and a look in? That's an interesting question. All of those are interesting questions. Technology really is challenging some of our basic concepts of privacy through the ability and the tools that are now available to intrude on our seclusion.
Well, for sure. Look, the police issue, and is certainly. I was looking at something with respect to the drone use by the New York Police Department. And look, let's face it, a drone comes a lot cheaper than a helicopter, and you can buy a heck of a lot of drones for the price of a helicopter. So, from a policing perspective, these things are potentially great tools. They'll save the taxpayer money and allow them to do their job, I suppose. But there's certainly that danger. There's that Orwellian danger that the state is looking over your shoulder at every moment in time. From a practical perspective, I don't want to discourage drone use. It's an industry. I think it's a valuable industry, both from an industrial and a recreational perspective. But people do need to be careful. So let's say you're using it as a real estate agent to show a property or as part of the marketing material. Make sure that you're carefully looking at whether there are any people in that footage, and blur it out if there's something there. People blur out license plates, for example, in news stories or other stories. So those are the kinds of things that you can do to protect yourself from a potential action. where somebody basically wants to say that, look, you can see me, or you can see me doing something in your video, and you weren't careful. So there are some practical things that the user can do to make sure that they're not inadvertently invading anybody's privacy, or certainly advertently. You don't want to do that either.
Well, that's an interesting point, though. That relates to two different concepts. When you were talking about blurring out, I'm thinking of Google Street View, for example. You can go on Google Street View and you'll see all the license plates are blurred out. You can see people walking on the street; their faces are pixelated, so you can't recognize them. But that is about publication. I mean, I think the whole tort of intrusion on seclusion in the Jones case, it wasn't that the defendant went out there not only and snooped around in the bank account, but then, published a web page showing what this person's transactions were. It was just the snooping around that was actionable. So whether you pixelate out the face or not, is the snooping around itself actionable as a standalone tort? If so, would there not necessarily need to be some intentional aspect to that? Wouldn't it have to be for, I'm snooping around for a nefarious purpose? Because I'm trying, like I'm doing this intentionally to hurt you, or to because I know that this is a private issue, but I'm snooping around anyways, knowing that. I think that may be the distinction, but I think it's actionable just to do the snooping.
Well, because there's an intent behind the snooping.
If there's an intent, it would be a requirement of a successful action, but the act itself is the snooping. Why one did the snooping is probably whether or not that's the intention part of it. But the actual act is, looking somewhere where one is not supposed to be looking.
Right, but that would make it an intentional tort versus negligence, which is, you do something unintentionally.
Yeah, it's my understanding of the tort of intrusion upon seclusion, at least as it was articulated by our Court of Appeal here in Ontario, is that it is indeed an intentional tort. It is not something that if I just am walking down the road and by accident I look at my neighbor's house and I look in the window and see something I shouldn't see, I don't think I could be sued for intrusion on seclusion. If I, however, I park myself with a telescope across the street and I'm looking in the window trying to find something because I don't like my neighbor, maybe I've got a problem.
Yeah, and look. If people have to have some responsibility, when you use any of these tools, right? You got to kind of govern yourself. Although there's no official code of ethics, there should be a code of ethics with respect to drone flying that people should adhere to. Now, I'm not.
Well, drone flying is just drones are just the, they're just the new binoculars, if I can call it that. And they're just an ability to see things and to an ability to gain access to places that one was not capable of physically gaining access to previously.
But look, I mean, as a device, although they've got 4 propellers, they can be reasonably quiet, and you're not necessarily going to hear a drone, among the other noises in a city. Honking car horns, traffic, construction work. You're never going to hear the thing. So it's it's almost like a bugging device in some respects. And I'm sure the military has probably developed, even smaller drones, that are probably the sizes of insects. So, the brave new world of drone flying and surveillance with respect to drones is probably, we're just starting down a slippery slope or at the bottom of a curve.
Yeah, I couldn't agree more. All very, very interesting issues, always balancing the fact that the law is always lagging behind somewhat with technology. So as technology increases at exponential rates, the law continues to drag behind it. But eventually, some of the fundamental principles that guide us in terms of what we think, we are entitled to, our rights, where we think our boundaries are, very important questions, and becoming more and more important as our technology increases. I think that's about all the time we have for this particular topic, an incredibly interesting one, and probably one we're going to see more and more permutations of in various aspects as technology continues to envelope every aspect of our life. So please join us again for another episode of Beneath the Law when we republish again. I think we're issuing every 2 weeks. So thanks so much for tuning into this episode. Please give us a rating. The ratings really help us in terms of understanding how we can make things better. And if we're doing things right, maybe we can try to do them again. But once again, Stephen, thanks for joining me. And always remember our favorite line: if no one is above the law, everyone is beneath it.